Most folks assume the traffic stop is the simple part. After all, you aren't the danger. You're the law-abiding citizen with a license, right? That's precisely how these horror stories begin. Right now, ordinary people, just like you, are being cuffed, losing carry permits, and stacking up $10,000 legal bills, every bit of it triggered by one poor sentence or one hurried gesture. I'm not here to frighten you. I'm here to hand you 4 precise sentences that can rescue you in court, on the shoulder, and inside every legal trap waiting to snap. Let's dissect each line so you stay shielded, stay lawful, and stay in command, no matter how ordinary the stop feels at first glance. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearm statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. Phrase 1. I'm not certain, officer. The baited question. Let's begin with something that looks harmless yet sinks gun owners again and again. It's the opener most troopers use the moment they step to your window. Any idea why I stopped you? On the surface, it feels like chit-chat. For an armed driver, though, that inquiry is a prosecutorial snare. Cop isn't being friendly. He's locking you into a story before he's revealed what infraction he thinks he saw. Once your personal wording lands inside his narrative, district attorneys will wield it later if the encounter goes sideways. Here's the mental pressure angle. You've been raised to be courteous. You're a decent human. You want to clarify. You want to appear truthful. You want the incident to end smoothly. So, when the deputy tosses out that prompt, most drivers dive into an explanation. Possibly, I was a little over the limit. Maybe I didn't quite stop. I was only glancing at my GPS. Each of those tiny clauses sounds innocent to you. Yet, here's the brutal fact. Under traffic statute, that becomes evidence. In every jurisdiction, whatever you utter is sewn into the officer's official recap. If the scene escalates, that recap is dissected by prosecutors eager to claim you confessed before your rights ever entered the picture. Now toss a handgun into the equation. It rewrites the whole mood. Even with a valid permit, even if you're positive you did 0 wrong, your sentences still sculpt the cop's viewpoint. If you begin apologizing before you know what the ticket alleges, a cop can read that as anxiety, deflection, or admission. He may enter, driver seemed evasive, or gave conflicting statements. That phrasing is exactly what the state uses to justify search petitions, permit revocations, or felony counts in certain states. There's also a courtroom reality civilians rarely grasp. In endless rulings, judges have declared that an officer's sworn report, especially one buttressed by the motorist's own admissions, carries heavy weight. Statements made roadside can be introduced under both traffic and criminal codes. In documented appeals, convictions were upheld not because of what the deputy observed, but because of what the driver blurted during questioning. That's why defense lawyers warn that your tongue can wound you worse than your conduct. It isn't showy sloganeering, it's evidentiary fact. Let's be crystal. This isn't about games or fibs. It's about defending yourself by refusing to volunteer data before you completely grasp the allegation. One of the commonest errors I see in pullover chats, particularly with concealed carriers, is motorists trying to rationalize behavior before they even discover what violation is claimed. They imagine, I'll clarify my action so the trooper realizes I'm harmless. Yet, until the trooper spells out what he believes you fouled up, you possess no factual footing to start explaining. That's why your opening reply must be, I'm not certain, officer, or just, I'm not sure. Uttering that lifts the weight. It doesn't come off hostile. It doesn't sound shifty. It sounds neutral. It informs the cop you'll cooperate, yet you won't cop to something prior to learning what it is. It also erases odds of fabricating a written confession inside the report. When you think about it, you're answering with what you legitimately know. You truly don't know why you were halted until the cop says so. That reply isn't sneaky or argumentative. It's accurate and legally wise. Picture a typical clip you might stream online. A trooper stops a commuter for what he views as a rolling stop. The driver instantly offers, I believed it was 4-way and I looked. The deputy writes, operator failed to halt fully and voiced confusion about right-of-way. Later, at a licensing board or traffic trial, that voiced confusion becomes ammunition against the carrier. Conversely, had the motorist merely answered, I'm not sure, officer, the paperwork holds only the bare stop data. That's the gap between a neutral file and one that morphs into evidence. Another authentic scenario involves escalation, sometimes absent wrongdoing purely from perception. When a driver over-explains before the deputy names the suspected infraction, it can read as jitters. In multiple documented incidents, deputies prolonged the detention detention, summoned backup, or heightened inspection merely because the talk grew murky. Once police ratchet up a stop, your statements become pivotal, not merely to traffic code, but to Fourth Amendment analysis of detention and search. This is likewise where solid citizens get tripped up by internet advice. Some trainers preach just be truthful, yet truth-absent tactics offers zero cover. Talking minus clarity isn't cooperation. It's handing the officer quotes that can justify anything from extended detention to a warrantless search. So here's the practical upshot. When something as mundane as a taillight pullover morphs into a legal hazard, you must treat every syllable like Exhibit A, because that's precisely what it becomes. When the deputy asks, "Know why I yanked you over?" your comeback should stay short, polite, and courtroom safe. "I'm not certain, officer." Watch how that line steers the exchange. It doesn't intensify. It doesn't admit fault. It doesn't invite an excuse you never meant to give. Most vital, it blocks you from authoring your own headache before you even learn the true gripe. Mastering how to speak less while still cooperating correctly is a discipline. It isn't arrogance. It isn't mistrust. It's self-defense. And it's the exact skill law-abiding carriers must drill long before they ever spot strobes in the mirror. Phrase 2. My license is inside my wallet. I'm taking it now. Kill the sudden movement accusation. You might be the calmest, most upright shooter on the asphalt. Shift wrong at the wrong heartbeat, and that entire image evaporates. When a patrolman reaches your glass and demands license and registration, most civilians reflexively dive for the documents. It's habit. We've all done it, yet if you're packing particularly concealed, that single unannounced lunge can flip the entire contact. From the deputy's angle, he can't see what you're groping for. All he views is a hand vanishing toward your belt line, glove cell, or console. That's the instant threat imagery ignites. In legal jargon, this is labeled a furtive gesture. Under Terry v. Ohio and decades of Fourth Amendment precedent, an officer may intensify a detention, even perform a limited frisk, or forcibly extract you if he decides your motion looks shady or perilous. And yes, he'll type it in the narrative. Driver made abrupt reach toward waistband, or subject lunged, failed to announce. Those clauses grant instant cover for a pat-down, vehicle toss, or additional units. You figure you're merely fishing out a card. He may figure you're drawing a pistol. That's why narration isn't optional. It's armor. The second the deputy requests paperwork, your initial answer ought to be verbal, steady, and specific. My license is inside my wallet. I'm taking it now. Then move slowly and deliberately. That sentence purchases breathing room. It broadcasts that you respect his safety. You aren't hiding contraband, and you aren't about to commit an act he can paint as menacing. Even in duty to notify states where you must declare you're armed, this step arrives first. You don't shout, "I got a piece," while plunging your hand downward. You narrate the motion, supply context, and allow the officer to dictate tempo. Remember, lawmen are drilled to value safety over assumption. Startle him, and you forfeit command of the scene instantly. After your license is visible, repeat for the registration. That paperwork's in the glove bin. I'll lift it next. Await acknowledgement, then shift again, slowly. Every motion deserves a spoken heads up. If he stays silent or fails to confirm, restate politely. Make certain it's captured, body mic, dash audio, or, at minimum, his mental notes. Once you've passed both items, both palms return to the wheel. Open, motionless. That alone can drop the tension 50%. It reassures the deputy you aren't a hazard. You won't fidget, and you won't force him to predict your next twitch. This isn't paranoia. It's narrative control. Your grip over how the stop is logged and later recounted, should matters slide sideways and the pullover land in a courtroom or licensing review, whatever is spoken, recorded, and typed becomes the entire ballgame. Real dockets exist. Scores where permit holders were indicted for felony menace, non-disclosure, or brandishing only because they lunged too fast without prefacing it. Some never planned to touch the gun. Some forgot it rested where the deputy could glimpse. Yet once the trooper's storyline brands it a threatening motion, the onus falls on you to disprove it. And here's the snag. If court day arrives, your even-tempered voice stating, "My license is inside my wallet. I'm taking it now," can serve as prime exculpation. On camera and in transcripts, it proves intent, discipline, cognizance of legal duty. Muteness, by contrast, invites speculation, and speculation routinely hurts. This whole slice may cost an extra 5 ticks of the clock, yet it can spare you months of litigation, thousands in counsel fees, even your carry privilege entirely. So, burn the sentence into memory. Rehearse it. Vocalize it every time you're lit up, even on days you're unarmed. Build the habit of announcing motions before you make them, because a single quick gesture, misread, converts a mundane pullover into a weapons beef. You aren't merely handing over documents, you're handing over the storyline of that stop. Ensure it's a version you'd be glad to hear played back in front of a judge. Let's pause a beat. If anything you've heard so far made you blink, if it revealed how rapidly one clause can flip your fate, smash that like, subscribe if you haven't, and forward this to a friend who's straps, because the next 2 lines could prove even more decisive. Phrase 3. I do not grant permission to search. Your constitutional sand line. It normally begins casual. The deputy hands your ID back, asks where you're bound. You answer, just errands. Then arrives the hook. You aren't holding anything unlawful in here, right? Mind if I peek around real fast? Most motorists freeze. They crave cooperation, so they mutter, yeah, sure, believing they've got 0 to conceal. Yet the instant you utter yes, you've signed away your 4th Amendment shield and delivered blanket approval for the cop to comb your cabin, your bags, every pocket, no warrant, no probable cause, just your own syllables swinging the gate. Here's where plenty, gun owners especially, blow it. They assume a soft no suffices. It doesn't. Inside a courtroom, mush like, I'd rather you didn't, or I guess not, routinely gets ruled as consent. Hesitate, stammer, look conflicted, and the deputy can still sell the search. Once you've okayed it, even half-heartedly, whatever turns up is admissible, even if it had no business being discovered. That's why the exact wording is critical. You voice it cleanly, calmly, sans attitude. I do not grant permission to search. Those 7 words erect a lawful fence. They inform the cop and any future jurist or DA that you invoked your constitutional immunity from warrantless fishing. It's courteous, it's unambiguous, and it shifts the load back onto law enforcement to color inside the lines. Let's be real. Armed motorists haul gear, spare mag, holster, maybe a backup blade. None of that is inherently shady. Yet what's lawful in your county can be outlawed 20 minutes up the road. A magazine that's fine at home might become a felony across a state line. Ammo storage statutes differ. Transport regs differ. Even a locked case sitting in the wrong seat can raise eyebrows. I've reviewed files where a consensual search birthed surprise counts. A lawful pistol wrapped in a towel was tagged improper transport. A cased handgun in a backpack was cited non-compliant storage because it wasn't announced. One motorist agreed to a sweep and was arrested for a pocket knife longer than the local ordinance allowed. Never knew the ordinance existed. 0 of those scenarios involved malice. All were legit permit holders who simply missed the fact that rules mutate between city limits. Yet, once the search commenced, gray areas calcified into charges and the drivers were left bankrolling their own innocence. That's why vagueness is poison. If your reply is mealy or sounds tentative, it will be spun. Appellate benches have repeatedly held that half answers like, I don't believe so, equal consent. Silence doesn't immunize you either. Shrug, clam up, or freeze, and case law lets the cop proceed. Your refusal must be unmistakable. I do not grant permission to search. And if the deputy leans in, why? Got something to hide? Stay level. You're not on trial. Simply restate, I do not grant permission to search. Repeating cements consistency, proves intent, and erases ambiguity should you ever stand before a bench. Suppose he proceeds anyway, orders you out, tosses the car without blessing. Don't argue. Don't physically resist. That's how a civil rights breach turns into a resisting collar. Let him play it out. Your crystal clear denial gives counsel ammo later. If anything is found and your refusal is on body cam, your lawyer can move to suppress. In most incidents, once rights are asserted, the officer backs off. Without your consent and minus probable cause, the continuation is illegal. But don't fold midstream. Some cops use quiet and delay to pressure you. They'll chat. Promise, it'll be quicker if you let me glance. Remain calm, repeat if necessary, and ride it out. Your mission isn't to speed the stop. It's to stay lawful while safeguarding your immunities. Saying no is not wrongdoing. It's exactly what the framers envisioned and what most civilians forget when pulses spike. So, lock it in. I do not grant permission to search. State it once, twice if pushed, then shut up. No elaboration, no justification, no chatter. The more syllables you feed, the more lines they scribble, and the more lines they scribble, the more opportunities they gain to twist your intent later. Your quiet isn't suspicious. Your clarity isn't combativeness. It's smart, it's constitutional, and it may be the lone barrier between a lawful detention and a lawful nightmare. Phrase 4. Am I being detained or may I head out? Your exit switch. Suppose the deputy has run your tags, returned your plastic, your piece is stowed legally, you've answered every query evenly, and 0 infractions remain. Yet, for whatever reason, he's still bedside, still jawing, still poking around the dialogue. At that instant, you're parked inside the riskiest slice of the stop, the hazy gap between a routine write-up and something far heavier. See, police don't always slap cuffs under swirling reds. Sometimes they just keep conversing. Casual chit-chat, nervous filler, requests for 1 more minute. Plenty of motorists wade straight into that bog because they don't realize when dismissal is allowed or how to terminate the chat. That's when this line morphs into armor. Am I being detained or may I head out? It isn't lip. It isn't defiance. It's a level, lawful thermometer that forces the cop either to release you or to confess you're being held without fresh justification. Either route hands the reins back to you exactly where they belong. Legal backdrop: Rodriguez v. United States, 2015, decreed that police may not prolong a traffic stop beyond the time reasonably required to handle the original mission unless they possess independent lawful cause. So, if the pullover was for speeding and that box is checked, they can't idle beside you hoping something pops. Doing so morphs into unconstitutional detention, yet it still occurs because most drivers won't challenge it. Courts won't rescue you unless you verbalize the magic question. Judges scan the transcript to see whether you asserted the right. If you never asked to roll away, the docket may treat your stay as voluntary. That means every statement, every extra minute becomes admissible, even if the stop should have ended 10 minutes earlier. Timing counts. Don't blurt it the instant you hand over paperwork. Wait until the topic wanders from the initial violation. Once you sense the core issue is wrapped, your credential is back, citation issued, or warning verbalized, yet he's still probing, still lingering. That's the cue. Calmly, clearly. Officer, am I being detained or may I head out? No snark, no threat, no ultimatum. You aren't demanding. You're requesting a legal status. That distinction matters. If he answers yes, you're free. Offer thanks and motor away. If he stalls, deflects, or starts new small talk, repeat, am I being detained or may I head out? That follow-up nails him to a decision and again manufactures a tidy record that you asserted rights rather than waived them. Fail to ask and the stop can ooze beyond your control. I've studied real files where civilians lost 15 extra minutes on the shoulder. In one, a guy sat patiently while the trooper finished paperwork, then got labeled evasive when he stretched in the seat. That furtive label justified a full vehicle toss, no fresh evidence, no contraband, just a weary twitch exploited as suspicion. Another driver joked about being late. The comment bought extra delay, then a summons for a drug dog. Result: 0 narcotics, 0 charges, but hours wasted. Interior gutted, dignity gone. The pattern never changes. The longer you linger, the deeper they dig, and the deeper they dig, the larger your jeopardy. Hence the sentence, am I being detained or may I head out? Isn't merely about getting home sooner, it's about reclaiming the border. Cops may investigate within reason. You may depart once that reason evaporates. Playbook recap. Once the mission is complete, license restored, citation handed, or warning logged, yet conversation drifts, you politely ask, am I being detained or may I head out? If he says no, you roll. If he says yes, seal your lips. Don't stuff the silence with chatter. You've just compelled him to justify the detention, and that single question can reroute everything that follows. Truth is, muteness won't rescue you, but one well-timed inquiry just might. That finishes today's rundown, folks. 4 sentences for watershed moments that decide whether you drive away or sit in court. Let's close with clarity. These lines aren't friendly merely hints. They're the exact legal tools that keep roadside chats from morphing into criminal dockets. Number 1. Blocks baited questions. Number 2. Wraps your movements in constitutional cotton. Number 3. Slams the door on surprise searches. Number 4. Most ignored, grants you the lawful cue to exit before the encounter festers. They aren't spells. They won't vaporize troopers, yet they tilt the field. They sketch boundaries courts respect. They prevent casual dialogue from blooming into felony indictments. Above all, they shelter you while adrenaline surges and judgment blurs. I'm not claiming every officer lives to trap you. I'm stating the machinery is wired to twist your words, so feed it fewer syllables. If this clip armed you with even one new tool or reminded you of something you'd let slide, make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.